अस्सलाम वालेकुम अगेन, वेलकम बैक टू कानून। और हम लाइव कॉल्स का सिलसिला जारी रखेंगे और हम क्विकली अगली कॉल लेते हैं। मिसेस पर्किंस, यू कैन टेक द नेक्स्ट
No problem. Welcome back to Law and You. I think we have some calls waiting. Can we take the first call, please? Hello.
अस्सलामुअलैकुम।
वालेकुम सलाम जी, कौन बात कर रहे हैं?
मैं मोहम्मद बात कर रहा हूँ।
यस मोहम्मद।
मेरे को मालूमात करनी थी कि मेरी बेटी हो गई है 18 साल की
और आप जी
वो अगले सितंबर के बाद यूनिवर्सिटी जाएगी।
ठीक है, लाइन ड्रॉप होगी, हम अगली कॉल की तरफ बढ़ते हैं। मोहम्मद आप दोबारा ट्राई करिएगा, आपकी कॉल ड्रॉप होगी। सॉरी अबाउट दैट। हेलो
Hello.
यस, हु इज कॉलिंग?
Hello, my name's Sarah. I'm calling from Kent, and I have a question for Mrs. Perkins.
Hello.
Go on,
Hi.
please.
How can I help?
Hello, hi. My question is, there's a man who's in this country. He came in this country as a student, then he got a work permit, and then he decided to get married, and now he's on a probationary spouse visa because he's only been married for 1 year, and he got married last year in January 2013. And now the marriage is in trouble. They've only ever really lived together for the first 3 months of the marriage, so they're now living at separate addresses, and the wife wants a divorce. So now he wants to switch his visa back to a work permit, which his employer is willing to do. But he's worried that he won't be able to do it while staying within the UK. He doesn't want to go back to Pakistan. He wants to stay in the UK and switch it here. Is there a way to do that? Because the key point is that he was on a work permit beforehand.
Yes.
And secondly, if as a last resort he does have to go back to Pakistan, is it possible that he, because he stays married and he won't divorce his wife, he goes back, applies there to switch his visa, and then he can come back to this country legally, and while the application is being decided, he would be living in this country legally, because somebody said to him he would have to go back and it would take a process of 6 to 8 weeks, and his employer can't give him time off for 6 to 8 weeks because they need him in the company. So we're just wondering if that's a loophole where he could sort of stay married and not tell the UKBA that he wants to divorce and just apply from there, and then maybe come back to this country legally and continue working. And if he has to go back again, he could go back again. And we're just wondering what the UKBA, what kind of questions they might ask him. Could they start going into the marriage? Why the marriage was only lasted? Why has it only lasted for 1 year? If they could start, becoming suspicious or anything like that. So please, could you advise us? Thank you.
Okay, thank you for the call. Okay, there was quite a few things within that call. I think the point to be made at the outset is, even though this gentleman might not want to divorce his wife, it won't necessarily stop his wife from divorcing him or contacting the Home Office to say that she no longer supports his application. So this might not be something that he personally has any control over. The Home Office can curtail his leave, which means restrict the 2-year probationary leave that he has and make that time a lot shorter. In terms of what application he can make, a work permit visa generally you would have to be able to satisfy the requirements under the immigration rules. There is also the option to apply for what's called as discretionary leave, which, while the application is being continued and while he's currently in the UK, he's entitled to stay here on the same basis on which he's currently got status, which is as a married person. If he was to go back, yes, there would be a delay because it's an entry clearance application that he'd have to be making. It might be a matter of persuading the employer to either give him a bit more time in order to make the application, as long as that employer has a sponsorship license in order to take him on. But a discretionary leave application can be done while he's in the UK and he can work. So that may well be a way around the situation. Circumstances about his marriage may well come in as an exceptional circumstances, relying on his human rights as well. Would you?
Yeah, I would like to add a bit. It's also a question of switching from one category to another category.
Yes,
so we need to find out whether he can. If its current status is
it's more than 6 months.
It's more than 6 months.
Yes, it's a 2-year probationary.
Then first question should be whether he's allowed to switch his category into Tier 2 category. The question actually would be whether his employer has got Tier 2 sponsorship license.
Yes.
And if he's got a license, then this gentleman would need a certificate of sponsorship, a CUS. And the key question would be which job he's going to offer, the employer is going to offer to this particular gentleman. In any case, the job should be of NQF level 6, and he must be a UK graduate. If he fulfills these two requirements, then he can possibly switch, qualify and then switch. So that would be something that he needs to find out in the first place, and then plan his way forward.
Good. Okay, can we take another caller, please?
Hi. Hello.
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 Yeah, hi there. Actually,
Who's
I
calling?
got married to a British citizen in October 2011, and she was my girlfriend since 2009. And when I sent my application for FLRM, they refused it in February 2012. And they said that because you're an overstay, you have to get an clearance from Pakistan. And I sent them a reconsideration under human rights. We've been a girlfriend, boyfriend, and we've been together for the last four years. And on top of it, I haven't got nobody living in my home country because they have moved to Canada. So if you can do this reconsideration under the Human Rights Article 8, they said, okay, we're going to reconsider it. After that, we send them letters time by time. After every few months, we reminded them by MP and that, but they didn't reply. Even they replied, they said, okay, we're going to consider your application in time. We got busy. We're really busy and this and that. But after that, last year in June, we took them to, we sent them a pre-action protocol that decided our application, otherwise they're going to take it to the High Court. We sent two pre-action protocol to them, and then after that, they took a free extensions from the High Court, and after that, Capita sent us a letter after 3 extensions that, okay, we are rejecting the reconsideration request that because your cases are already in the High Court, so get the decision, whatever they're going to give, we're not giving you a decision. And then my solicitor wrote a letter to Treasury Solicitor saying that this is not fair, that my client has been waiting for this long because of your Home Secretary promise that we're going to reconsider it. And now you're saying, so the Treasury Solicitor, in return, they sent us a letter with it was a consent letter. They said that, okay, we're going to decide your application. We take that capital letter decision back, and we're going to give you 3 months' time. And in between that time, we will decide your application. There is going to be no cost from both sides. So what do you think that, I mean, from this case, do you think there is a good chances that we can get discretionary leave? And do you think that they're going to decide my application this time in 3 months' time? Because it's been over 2.5 years, we've been married, and my case is pending for over 2 years. They haven't decided anything yet. So if you can please tell me in detail.
Okay, thank you for the call. Okay, the stage that you are right now with the consent order with the Treasury solicitors, if I can maybe explain the procedure. Once you've lodged a judicial review application, your case is then not only dealt with by the Home Office at grassroots level, it's actually dealt with by the barristers for the Home Office, which is the Treasury solicitors, who are legally trained. Now, the agreement of the consent order is something that's binding. So the question that you posed, would the Home Office be looking to make a decision within 3 months? Yes, they have a legal obligation to do so. I did note that you said the consent order said that a decision would be made within 3 months and there would be no order as to costs. What I would suggest is that you go back to your solicitor and ask to come to some agreement with them. This is a common tactic that the Home Office via the Treasury solicitors like to do. We always urge for costs, because you are inconvenienced, not only by way of the delay, but by way of costs. So therefore, I would ask for the consent order to be written, if it hasn't already been finalised, that costs are given to you, reasonable costs, and then you'll hopefully get the decision within the 3 months time frame. There's no real indication even if they do have a consent order as to what the outcome of that decision is going to be. But as long as you can ideally provide the Treasury solicitors with updated information, sometimes the Home Office will ask you for further information within that 3-month time frame to assist them in making a decision. So I would say you're more likely than not to get a letter from them asking for further evidence. So start collating further photos and evidence of living together for the whole duration of your marriage as further evidence to hopefully persuade them to make a favourable decision on your case.
And because he has already completed 2 years
of course.
In that relationship, so at the current time, at the current date, it's a stronger case than before.
Yes, it definitely supports it. Hope that assists you.
Thank you for your advice. We'll proceed to the next caller.
Okay.
Hello.
हेलो जी, अस्सलाम वालेकुम।
वालेकुम सलाम।
जी मुझे ना
नाम कौन बात कर रहे हैं, कहाँ से, कौन बात कर रहे हैं, नाम बताइएगा अपना जी।
सॉरी,
हेलो, नाम बताइएगा अपना, आपकी आवाज़ कम आ रही है।
मेरा नाम रुबीना।
जी रुबीना, कहाँ से बात कर रही हैं और आपका क्वेश्चन क्या है?
मेरा क्वेश्चन है कि एक तो मुझे जेआर के बारे में पूछना है कि उससे कितना टाइम लगता है, और दूसरा जो ये 7 साल का बच्चों के बिहाफ ये जो एप्लीकेशन रिफ्यूज कर रहे हैं, तो इसका क्या बनेगा? इसमें हमारा भी इन्होंने
जी ठीक है, मुझे आपका सवाल समझ आ गया। इसके अलावा कुछ आपने क्वेश्चन पूछना है? आपने 2 सवाल पूछ लिए ऑलरेडी।
जी, मुझे यही पूछना है और अली साहब से मिलना भी।
जी, अली साहब के बारे में आपको बताया कि वो साउथ हॉल में अपने नए ऑफिस के सिलसिले में बहुत बिजी हैं। वहाँ पे वो इसी तरह से कंसल्टेशन प्रोवाइड कर रहे हैं, एडवाइस दे रहे हैं। इसलिए हम उनको कवर करने के लिए आज यहाँ पे आपके साथ मौजूद हैं। आप मिस पर्किन से सवाल पूछ सकते हैं, मुझसे बात कर सकते हैं, और अगर आप उनसे मिलना चाहें अली साहब से तो आप उनके साथ मुलाकात भी कर सकते हैं। आपकी कॉल का शुक्रिया। मैं आपके सवालों का जवाब लेता हूँ। शुक्रिया जी। This was Rubina calling with 2 questions.
Okay.
First of all, she wants to know the processing times for JR, and because we have so many calls on this 7 years policy, 7 years question, because there are so many refusals to these applications based on 7 years in the UK. So people are, particularly in this particular caller, is interested to find out what's the way out, how to deal with this refusal.
Okay, so if I can just clarify, they have a child who's been here for 7 years.
For 7 years, and the application has been refused,
right.
which was made on the basis of the 7 years spent in the UK.
Okay. Right. Generally, the Home Office policy seemed to be that where there's cases involving children, they would actually give them an in-country right of appeal. But despite that, we are, seeing on a kind of a repeated basis that the Home Office are just refusing it with a standard 2-page letter with just the person's name and date of birth, kind of a nationality changed, if it's changed. Sometimes it's not. The main aim is to try and give as much information regarding that child as possible. So it's one thing saying, well, look, my child has been here for 7 years, they attend school. Elaborate. What school do they attend? What extracurricular activities are they involved in? What friends have they formed here? Provide photographic evidence. Do they speak the native language, for example? Because if they only speak English, it will affect them being able to adapt back home. Because the question is not only, do you have a child who's been here for 7 years and has adapted to life here, but also, is it unreasonable for them to go back? And it would be unreasonable if they're doing very well here, they don't speak the native language, and they're fully settled here. So the only way forward would be to challenge the Home Office, and they are being challenged quite often. And when you do get to the stage of being able to liaise with the Treasury solicitors by way of a judicial review application, at that time it's really to push not only for a case to be determined, they generally say within 3 months, also ask for costs, as I mentioned to a previous caller, and if possible add to that an in-country right of appeal should the Home Office not make the right decision even if they have reconsidered it. They can still come back and say no. But if they do come to do that, that you actually push for a right of appeal while you're here in the country. But definitely just trying to get as much evidence as possible to support the child being here. Don't just rely on the child is here, but what are they doing?
And there was a question on JR processing times.
Okay. The JR application, judicial review, which is JR application, has to be made within 3 months of the refusal, the date of the refusal. Because of the huge amount of judicial review applications that are currently outstanding, they can be dealt with within 2 to 3 months. We can possibly get a decision within that time. However, as one of the previous callers also highlighted, there is a certain time frame in which the Treasury solicitors are supposed to acknowledge the judicial review grounds, the grounds on which you're making this application. And they often are unable to meet that deadline, which is why they keep applying for extensions. And there is a recent case that went before the High Court where people were challenging the Home Office and saying, well, it wasn't unacceptable for people to have to wait continuously. And the general viewpoint is that the High Court will only accept one extension request made by the Treasury solicitors. Thereafter, unless there's very extenuating circumstances, they are demanding that the Home Office actually make a decision and respond to the acknowledgement of service.
Thank you, Mr. Perkins. I just wanted to ask you one general question on this 7 years qualification. When the Home Office say it's part of the immigration rules, the Appendix FM, if the child has spent 7 years in the UK, they are going to grant leave to the whole family. Yes. What do the rules actually say, and how the Home Office are implementing it? Because we see so many refusals of these applications, 7 years applications. So what is the general understanding? Because I see a difference between the general understanding of the public, the applicants, and the Home Office position. Because general understanding is that if your child has spent 7 years in the UK, you're going to get the leave. So what is the fact of the matter?
Okay, I think this goes to the point of the next part of the question, which is it reasonable for the child to leave the UK? And I think often the public, as it was, stops short at my child's just been here for 7 years. They are refusing if the Home Office can prove that the child knows the language or can adapt to the education system back in the country of origin. So it's mentioning, is it unreasonable? So language may well be a factor. Education could be a factor. Have they travelled there before? The climate, the weather, could be a factor, depending on if the child has any medical issues. And what they're doing here, it's not just 7 years. I think we need to look at this in a more in-depth, elaborate form, because this is what the Home Office are doing. They are refusing, often for no real reason. Okay, so I think we just need to kind of look beyond just 7 years and look at the detail of what's going on with that child.
Thank you for such a well explained advice on this. I would like Rubina to understand this, because your question, Rubina, is it's actually a question which we are receiving so many questions, so many calls on this subject. The 7 years policy, मैं अब उर्दू में एक्सप्लेन करना चाहूँगा आपके लिए कि जो 7 साल का सवाल आता है, बहुत से लोग रिफ्यूज़ल मिल रहे हैं, उनको रिफ्यूज़ल्स एप्लीकेशंस जो उनकी 7 साल की बेस पे हैं उनके रिफ्यूज़ल मिल रहे हैं. लोगों की आम अंडरस्टैंडिंग ये है कि जब बच्चे 7 साल यहाँ पूरे कर चुके हैं, आप एप्लीकेशन करें, आपको लीव मिल जाएगी पूरी फैमिली को. अभी मैंने मिसेस पर्किंस से यही सवाल पूछा कि असल मामला क्या है, रिफ्यूज़ल इसमें क्यों आ रहे हैं. उन्होंने इसको बड़ी अच्छी तरह वजाहत की है. बेसिकली जहाँ तक 7 साल की रिक्वायरमेंट है, उसके साथ एक और चीज़ भी है कि क्या बच्चा, होम ऑफिस ये भी कंसिडर करते हैं क्या इस बच्चे को यूके से बाहर वापस भेजना जो है, क्या ये रीज़नेबल है, इस सवाल का जवाब आपकी एप्लीकेशन को, जब भी आप ये एप्लीकेशन डालें, उसको कवर करना चाहिए। ना सिर्फ 7 साल पूरे किए हों, बल्कि क्या वो रीज़नेबल है कि उसको वापस भेज दिया जाए आप उसके कंट्री ऑफ नेशनलिटी में, जो भी कंट्री हो। तो इस सवाल का जवाब जो है वो आपको प्रॉपरली देना चाहिए जब भी एप्लीकेशन करें। तो जैसे मिस्टर पर्किंस ने पहले एक्सप्लेन किया था, जब भी एप्लीकेशन करें तो जितनी ज़्यादा मुमकिन हो उतनी इन्फॉर्मेशन दें, ज़्यादा से ज़्यादा इन्फॉर्मेशन दें। फॉर एग्जांपल स्कूल के बारे में, उसके एक्स्ट्रा करिकुलर एक्टिविटीज़ के बारे में, लैंग्वेजेस वो कौन सा बोलता है, कौन सी नहीं बोल सकता, फ्रेंड्स कितने हैं, उसके बाहर कौन कौन से एक्टिविटीज़ में स्कूल के अलावा इन्वॉल्व होता है, क्लब्स, सोशल एक्टिविटीज़, चिल्ड्रन एक्टिविटीज़, सारा कुछ। और फिर ये चीज़ क्लैरिफाई करें कि क्या वो वापस जाएगा तो अपने कंट्री ऑफ नेशनैलिटी के में अडेप्ट कर सकेगा, वहाँ की क्लाइमेट, वहाँ के एजुकेशन सिस्टम, वहाँ की लैंग्वेज के एतबार से। अगर इन सवालों का जवाब आप नो की सूरत में आगू कर सकते हैं, दैन उम्मीद है होम ऑफिस 7 साल की रिक्वायरमेंट्स के से इजाफी, इन एडिशन टू द 7 years रिक्वायरमेंट, अगर आप ये इन सवालों का जवाब आगू यस में कर सकते हैं तो होम ऑफिस उम्मीद है इस ऐसी एप्लीकेशन को रिफ्यूज़ नहीं करेगा। So it's the second part, the reasonable, whether it's reasonable for the child to require to leave the UK or not. That is the key question for these applications in addition to 7 years requirement. सर आपने JR के प्रोसेसिंग टाइम पूछा था, मिस पर्किन ने बताया है 2 से 3 महीने है, लेकिन जो ट्रेजरी सोलिसिटर्स हैं, होम ऑफिस के सोलिसिटर्स, वो एक्सटेंशन आजकल बार बार मांग रहे हैं क्योंकि रिफ्यूज़ल बहुत ज़्यादा हो रहे हैं, लोग JR की तरफ बहुत ज़्यादा जा रहे हैं, तो एक्सटेंशन मांगते हैं कि जी हमें और जो टाइम दें केस प्रिपेयर करने के लिए। तो उसकी वजह से एक एक्स्ट्रा टाइम, समटाइम 2-3 एक्सटेंशन हो जाती हैं, तो काफ़ी एक्स्ट्रा वीक्स लग जाते हैं। आपकी कॉल का शुक्रिया, उम्मीद है आपको तफसीली जवाब पसंद आया होगा और आपकी रहनुमाई के लिए जो मालूमात मिसेस पर्किन से मिली वो आपके काम आएंगी। बल्कि ना सिर्फ आपके लिए, बल्कि हमने इसको इतनी तफसील से आज डिस्कस किया है कि बाकी जितने कॉलर्स हैं उनके भी सवालात के उम्मीद है जवाब उनको मिल चुके होंगे। आज के प्रोग्राम को हम यहीं पे ख़त्म करते हैं। आपकी कॉल्स का शुक्रिया। अगले हफ्ते हम दोबारा हाज़िर होंगे एक नए मौजू के साथ, जिसमें हम कोशिश करेंगे कि किसी एक पर्टिकुलर मौजू पे कॉल्स भी लें। इस हफ्ते तो मिस्टर बुखारी बिज़ी हैं, अगले हफ्ते वो ख़ुद शो करेंगे। उम्मीद है कि अगले हफ्ते वो आपके साथ ख़ुद बातचीत करेंगे और आपको मुशावरत और रहनुमाई देंगे। हमारा राब्ते के लिए आपको ईमेल एड्रेस और कुछ कंक्लूडिंग रिमार्क्स मिसेस पर्किन से लेते हैं, वो आपको अपना हमारा ईमेल एड्रेस भी बताएंगी। मिसेस पर्किन, जस्ट अ फ्यू concluding remarks and our email address for the...
No problem. Okay, well, thank you everyone for tuning in. Mr. Bukhari will hopefully be here with us next week, so hopefully you can go through any queries that you have regarding immigration matters. If you do have any queries, by all means contact us on our email address, which is info@bukharichambers.com. And we do have the new Southall office open as of today, as I mentioned earlier, and we are currently kind of unfolding the free consultations and community service this week. So there'll be free consultations in our Southall office. So if you do have any queries that you might not have been able to get through to us today, by all means contact us and we'll arrange for you to come in and see us at our Southall office.
एंड इन द अल्टरनेटिव, मुतबादल के तौर पे आप हमें अपनी सारी क्वेरीज जो हैं वो ईमेल कर सकते हैं, जो ईमेल आपको स्क्रीन पे नज़र आ रहा है। मैं रिपीट कर देता हूँ, इट इज़ info@bukharichambers.com। हमारा साथ देने का शुक्रिया। अब हम इजाज़त चाहते हैं आपसे। अल्लाह हाफ़िज़।